What's up, everybody? Welcome to the Better You Project, optimizing health, hormones, and aesthetics. And today I have two really amazing special guests that I've been dying to get on my podcast, and we finally have narrowed down some time to do it. I've got Shamika and Wakaba, and today we are going to be going over some of the legal scope of practice things about integrative medicine. And so I'm going to let each of them introduce themselves and a little bit about the style of law that they practice, and then we'll get into it. So Shamika, do you want to go ahead and get started?
Yeah, perfect. Absolutely. I have to start being a lawyer with the legal side and say that our participation in this discussion is about the legal environment of med spas and peptide therapy. This podcast is not providing legal advice, as every situation is different. And so if you have actual legal questions, please consult with a professional. Additional background, my name is Shamika Mazyck. I'm a senior associate at Quarles Brady. I practice in our Indianapolis office. I focus on healthcare, transaction, and regulatory information. A little bit of background, I worked in a hospital for 9 years before I went to law school. It was a 700-bed hospital. And after practicing for several years, I managed occupational health and therapy programs. I realized I was accountable to the numbers, but no one was accountable to me. And whenever I tried to build accountability, the lawyers always told me no. So if you can't beat them, join them. I went to law school, graduated in 4 years through the evening program, and have been practicing for 6 or 7 years in the healthcare regulatory space. So excited. Thank you for the invite. And I will kick it over to Wakaba.
Perfect.
Hi. Hello. Hi, I'm Wakaba Tessier. I've been actually doing healthcare regulatory law since 2009. I regularly represent med spas. And so I think this podcast, I'm really looking forward to it. I think this whole space that we're talking about today is really active. There's a lot of PE interest, private equity interest in it, but a lot of the issues that we talk about, they actually come up on a regular basis, even within the deal work that we do. And so I'm really excited to be here. And I'm also a partner at Quarles Brady, the same firm as Shamika. So thanks so much for having me.
Yes, perfect. And just as the lady said, that this does not constitute as legal advice, that you need to consult with your own medical malpractice team, your own attorney or attorneys like us. And we're super excited because it is it's gray, but it's not gray, if that kind of makes sense. And so a lot of times what I've learned navigating through the integrative medicine world and the aesthetic medicine world is that it is very state dependent. And I think, having a good, knowledgeable team of attorneys that you can work with is going to be absolutely crucial to the success and the safety of your practice. So now that we've said all that, let's jump in. All right, perfect. Okay, so first kind of section I'd love to get into are some of the legalities of med spas. What are your guys' thoughts or experiences when it comes to non-clinical people owning med spas?
So I think I will start, and then Shamika, you can chime in if you have something to add. But we're talking about what's called in the legal world called the corporate practice of medicine, or the prohibition on the corporate practice of medicine. And what that is it is a concept that tells you whether or not a lay person, a non-licensed professional, can own a medical practice. So, like at the outset, I said there's a lot of private equity interest in the medical spa space. Every time we do a transaction in a state, we need to first look at whether or not there's a prohibition on the corporate practice of medicine, because that then informs us whether or not the PE firm can straight out buy the practice, or if we need to set up this special, it's not special, we do it all the time, but what I call the friendly PC model, where it's a management model and it's sort of a way to get around the prohibition on corporate practice of medicine. It does vary state by state. So in Missouri, there's no corporate practice of medicine. So you're free to go out and start your LLC. It doesn't need to be a professional corporation or a PLLC, a professional LLC. So that's good. In states like Arizona, for example, there's no prohibition on the corporate practice of medicine, but if you are not licensed, then you need to actually go get a license or a registration with the Department of Health. So there's various nuances. California, for example, is a very strict corporate practice of medicine state. So, there's different challenges. We really need to be careful on how to set up that friendly PC model that I talked about. And so, again, it is a state-by-state analysis. And depending on how much there is enforcement in that area, we try to it's the general same model, but we might tweak the compensation methodology. We might tweak some of the agreements that we put in place with respect to corporate practice of medicine. So certainly that's something that we keep abreast of on a day-to-day basis.
Yeah, no, that's great. And it's super, super fascinating. I think, one of the considerations is, you've got the business side of it, but then you've got the clinical side. And part of the piece of it is I train for a big aesthetics company. And so I go in and I'm talking about product and why this product versus this product and the type of patient base. And one of the saddest things that I hear is, injectors will say like, well, the owner wants us to use this product. And I'll say like, oh, okay, like, can you tell me why? And they're like, well, because they got a discount on it or because they got a deal on it or this. And it's like, do they inject? And no. And I'm like, so they're basically making clinical decisions without being a clinical person. And that's the problem that I kind of have with that type of issue, is, leaving it to the clinicians, I think, to make the clinical decision making, because that's what our specialty is, right? What would you say, guys, is what I know you mentioned California, which is like in a lot of ways one of the most strictest states when it comes to like all the integrative stuff that we do in recommendations. What are some of the more restricted states that maybe listeners need to be aware of?
I would say Oregon is another one. Texas is another one. Oregon, the actual practitioner has to have a majority share. That also matters if they're doing an integrated practice with the nurse practitioner. The physician still has to be the majority owner. I think your point lands exactly on why the corporate practice of medicine exists, is you don't want business people making medical decisions. I think that's also why that's getting so much attention in the private equity space. Any other states you know of, Wakaba?
I think, so this is just as an aside, this is a legal tip. But, this is, like we said, it's a state-by-state analysis. But when we sort of tackle, some clients come to us and say, hey, we want to know the corporate practice of medicine for all the states, right? But that can get expensive. So we sort of tend to focus on kind of the big five, depending. But for sure, California, Texas, New York are kind of the big ones. And then sometimes, depending, we might do Illinois. I don't know, Shamika, obviously it's client dependent, but those are kind of the big ones we start with. And those tend to be the more restrictive ones, right? So, if after this podcast, you think, oh my gosh, we need to figure out this corporate practice of medicine, and you have sort of, big aspirations to go out to all 50, my recommendation is to kind of focus on those big states first and then narrow it down, because guaranteed it'll be easier to do the harder states first and then go down to the less restrictive states. And from a budget perspective, I think it's also a good idea to cover those bigger states and then go down to kind of the more less populated states.
That's a great point.
Yeah, perfect. All right, perfect. Well, shifting gears just a little bit here, I'd love to talk a little bit about IV therapy, IV bars, getting IVs without in my opinion, a proper workup, which would include, blood levels, looking at renal function and hepatofunction and electrolytes and all those things. What would you guys say are some of the risks and legal implications when offering either like mobile IV therapy or like, IV therapy at like a bar? And I'm seeing a lot of these mobile things pop up, what is the significance in your eyes?
So I have dealt with questions about how to deal with this. Certainly from a patient consent perspective, we can try to put in as many guardrails as possible, something along the lines of, you agree and acknowledge that you've provided us all of the information that pertaining to your health, You know, I agree to hold harmless, your practice, because I've given you all of the details related to my health, and then you go ahead with the IV therapy. That said, in some states, those kind of hold harmless language is not upheld when it comes to litigation. When it's actually being litigated, it might not be enforceable. It also does not replace the diligence that medical professionals really should be doing and documenting, right, in the event that there is a malpractice suit. So from a best practices perspective, notwithstanding kind of that hold harmless and indemnification, all that kind of lawyerly language that you see whenever you go to the doctor, notwithstanding that, I think it's really important to do a verification of your medical condition. Again, your best practices is, if you can, to see records of, whatever the professional thinks is appropriate. It might be, your most recent lab work. It could be your weight, depending on the type of therapy, the IV therapy that you're getting. So that's where I stand is, yes, we can put in, we as lawyers can draft all of that CYA precautionary language as possible, but it doesn't eliminate all of the risk.
Right. Yeah, absolutely. And I'm not sure if you saw, I think it was earlier this year, unfortunately in Texas, there was an incident where, a patient was unfortunately harmed through some IV therapy. She was getting in a med spa. And so, I'm just reading off of what the news said, but digging through it, it was more in that they had like standing orders, right, from a medical director who is like 4 towns away, and maybe the person administering the IV was not an RN. And so like having that skill set of, things that we learn as far as like troubleshooting, airway, breathing, circulation, doing this, all those things. And so it can be, very, very gray in some instances. And, I can tell you, IV bars, for example, where they have a medical director over that franchise. And it's like, but do they really know what
what do they do?
Yeah. And so it's just like, I don't know, it just gives me a little pit in the gut that I'm like, that sounds like a terrible idea. That sounds so bad,
Yeah, I can add, I think states are starting to pay attention to this. Like the California Board of Pharmacy just recently during their board meeting started talking about language to go out, not just to the practitioners, but from the Department of Health to the public to have to post on this, to be aware of those risks so the public can know because of some of those adverse events.
Yeah. The unfortunate thing too, I would say is that it's almost like, who is policing it? It's almost like not policed until there's an adverse event. And then it's like, then you start digging the pieces and as a clinical person, I'm like, I can see kind of some of where the like things could have been maybe better managed, kind of thing, which again, it's not great for us, for those of us who do offer IV services. And so like in our practice, we offer IV therapy, but you have to be a medical patient of the practice. And the reason why we do that is because I've looked at your renal function, I've looked at your blood pressure, I've looked at your kidney function. And yeah, it sucks sometimes turning that business away. Like, oh, my cousin Joe is in town and he was golfing all day and can he come get a Myers? And I'm like, no, because I don't know your cousin Joe's history, So that's what gets a little bit difficult. Well, I'll just go to the IV bar. And I'm like, okay, so yeah, it can get a little dicey. Next kind of section here, shifting gears again. It's like rapid fire. We're just like cranking them all out. I love it. Let's talk a little bit about peptide therapy. So peptide has obviously become increasingly popular, more so recently with some of the GLP-1s on the market and things being on national back order shortage through, commercial manufacturers has given the ability of compound pharmacies to do that. That's truly the only way that they're able to do that within their scope is because of the national back order shortage for that reason. When you are maybe encountering practices who want to offer peptide therapy, is there like a list of certain things that you think need to be like on the consent, or are there certain things that you guys see like this is kind of what legitimizes your program?
Yeah, no, absolutely. That's a great question. I think, at a high level, informed consent is the process of you educating the patient about the risk and the drug and the treatment. And so from an informed consent perspective, every peptide therapy is probably for a different treatment or a different condition. So there shouldn't necessarily be a standard one. I can't think of any other risk where you just blanketly accept everything.
So glad that you said that, because that's literally a question I get asked all the time. They'll say, you have a consent for every single peptide? I'm like, yeah, because every single peptide does something different. Like, do you have one general, this is my surgery consent, whether you're getting a chole or an appy? Like, no, like it comes with its own risks and its own side effects. So I'm so glad that you said that. I'm probably going to put that on the reel as like let's play that 24 times. Every peptide needs its own consent. Say it again for the back. They need their own consent. Okay, sorry. So, okay.
Louder to the people in the back, but no, yes. you absolutely should. Different treatments, different risks. From a legal perspective, there's certain elements that should be in there. One, what is the treatment for? What are alternative treatments? What are the risks and the benefits of this treatment? What are signs of potential adverse effects? And what's a number or someone that you can contact if you have those different adverse effects? From an operational standpoint, there's things you consider. You should make sure that when you're scheduling or having these conversations, your appointments allow times for the patients to ask questions and for you to explain things to them. Additionally, when you're engaging in these conversations, we've all been in conversations where you've looked at someone and explained something and it's just glassing over. They have no idea. So you kind of have an ability when you're having that conversation to make sure that they understand. And then finally, an attestation. Typically, you have the patient sign something that says that they've had the opportunity to ask questions and that they understand. And you rely on your own due diligence or standard of care to give that consent. I know that sometimes providers have said, well, the pharmacy has an obligation to provide counseling too, either written or oral. And so they're getting it dual way. That's completely independent of the practitioner's responsibility to provide that informed consent. And so though they're just some key element or like practice ideas, you want to make sure you meet the standard of care. What would a reasonable practitioner in that similar situation say that patient should have known, or questions that they should have asked, so that they're making the informed decision about their own health?
Yeah. I can also add that documentation is key. This is true for all general compliance, right? Like if you're going to prescribe a GLP-1 and I feel like everyone's like, "Ooh, I want that for myself." Maybe there are some patients who may, be appropriate for that standard treatment, but if you don't write it down, no one's going to know, right? And so again, when that bad thing happens and there is an issue that comes up, if you don't write it down and if you don't document it, you can't then later say, well, at the time I thought this was appropriate for you, but why? So, along with the informed consent and being able to ensure that the patient truly understands what they're getting, I think it's also on the back end from the practitioner perspective, it's super important to document that, because if you don't, it didn't happen.
Yeah, that's a great point.
Yeah, absolutely. I think one of the things that we really pride ourselves on fun fact, our nurse practitioner, Shamika is her sister. So Siobhan can speak to this also, is we do a ton of education, tons with our staff and with our patients. And the reason why we do that is because we want them to fully understand that these are not mainstream treatment options and that there are alternatives to mainstream, but they know then why we're doing what we're doing and how we're doing it and what are the side effects. And so I feel like that if you're a practitioner and you are listening and you are adding in peptides, like you need to do a great job at educating your patients, whether it's you've had that consult and then you send them home with something. Like we do a podcast, right? And so we have patients who listen and we have practitioners who listen. But I can't tell you how many times our NPs and they're doing a new consult and they're like, listen to episode 22. It's all about GLP-1. So they kind of have a little bit of education that does not take the place of a consult. But it's like, okay, you've done your homework. You're coming in. They actually know what questions to ask when they come to their appointment. So they make the most out of their time with us, which I think is great, which is why we put out this content. So I think that's so important. So thank you so much for commenting on that, because I think that's absolutely huge. Kind of next, piece of that is, so we've talked a little bit about peptides, we've talked a little bit about aesthetics. We don't learn this in traditional nurse practitioner school or traditional med school. What would you say as far as like scope of practice? Who are the specialties that you are seeing practice this kind of medicine, or seeking out your services for additional, legal counsel?
So I can start, and then Shamika has actually done a lot of work in this scope of practice, but I can share anecdotally that I used to work with a client that had an integrative medicine. It was a medical practice and kind of a med spa like that you really see, but this was years ago, so it was more innovative. But one of the first things that we did was kind of list out all of the services that were being provided, who was going to provide it, and who was going to supervise. And really, it's all about scope of practice. When we say scope of practice, it's all about what your licensure allows you to do. Personally, what your licensure allows you to supervise, like what procedures, and then what can you delegate, and to whom can you delegate? And really, we go through this exercise, though tedious as it may be, is really to protect your license and make sure that we minimize potential risk. And I know, when we talk about scope of practice, we just want to ensure that no one is outside the bounds of what they're allowed to do, to make, and it's really for safety reasons and to minimize the potential, issues that may come up. And if they do, we can have the story to say, listen, we're doing this pursuant to the scope of practice. We were perfectly fine in delegating X, Y, and Z services to an LPN or a nurse practitioner is allowed to supervise a lower level practitioner for X, Y, and Z services.
Yeah, no, that's a good point. And I think the only piece I would add to that, the scope of practice is, part of it is you have to show, again, going right back to that standard of care, that you have the proper training and education for that patient population for that condition. And it's not just, the training and education and how to do the initial administration, but how to handle any adverse side effects that go wrong. So if you're a nurse practitioner that practices in a pediatric setting, right? And then all of a sudden you're working with adults and prescribing peptides, like, do you have that proper training and education for the adults that you're working with? If you're a dentist, right? Do you have training and education as it relates to some of these other conditions? And so it really is the full scope, not just the initial treatment, but the maintenance of that treatment and the maintenance of those adverse reactions. That all should show, like, your education, training, background should all support that you're qualified to meet the standard of care to provide that training. And so, I think, it's not necessarily just a certain practitioner type. If you look at that training, look at that first, that will lead you to general practitioners, nurse practitioners, physicians that provide that type of training because they have the right education and the right background.
Yeah. No, absolutely. As one of the things that it's one of our pillars of our practice is education. In functional medicine and aesthetics, there's not so to be a nurse practitioner, you go get your master's degree, you sit for the board, it's very legitimized. It's so hard in aesthetics and in functional medicine because there's not a set standard. So I'll give you kind of on the aesthetic side, 2 examples in our practice is I did a fellowship through the Academy of Anti-Aging in aesthetics because I wanted to legitimize, I got some training behind my name when it comes to doing this. And then our aesthetic nurse, her name is Carmen, she sat for the certified aesthetic nurse. So that is the highest level that a aesthetic nurse can hold as an RN. And so, we have those 2 credentials behind our name because there's not a master's degree in aesthetic nursing. There's plastics, there's cosmetics, but for nurse practitioners, that's kind of it. So that's on one side of the house, that's on the aesthetic side. So if you are a practice or you're a practice manager and listening, I would be really encouraging to your practitioners to get that piece of education, because God forbid if they ever have to go before the board, well, what training have you had? You can say, I've done a fellowship in this training and I've treated this many patients with this modality. So you got a little more street cred behind your name. On the other side of it, on the functional side, and I'd be curious to know if you guys have any other additional recommendations. I've been practicing peptide therapy for the last 6 years, and I probably have done 4 or 5 different certifications through many of the organizing peptide education bodies. And every time I get a certification, I will submit like a copy of the certification to our malpractice attorneys. And just in case, God forbid, one day I ever have to go defend what I do, and they say like, oh, you're just a nurse practitioner prescribing peptides. It's like, whoa, hold up. Like I've sat through this training. And not only that, I speak on it and I teach on it and I have a training academy. And so I'm not some fly by the night practitioner, which I think being an NP is a little bit harder because we're always going to be held to the higher standard because we're just NPs. And I love being a nurse practitioner. I wouldn't change it for anything in the world, but I think we need to hold ourselves to a high standard when it comes to doing these things, because there's not like a set master's degree. And same with functional medicine. So I did my training through the Institute for Functional Medicine, which is in functional medicine. That's like the highest standard you can get. And it was hard. It took me a couple years to do it. But again, it's one of those things that I try very hard to make it legit as far as what we're doing, because it is so out of the box. And we are in Indiana. And so they're just like, you're doing what? So I think that's absolutely important. Is there anything else, ladies, that you guys can think of that would, I don't want to say protect your license, but maybe like give you a little bit more credibility that you can think of?
I think the training that you mentioned is absolutely key. But again, I think I go back again to the informed consent conversation we had earlier, right? I think really minimizing risk is all about. And risk really arises a lot of the times from patient, complaints, right? Because you're not going to stop anyone from filing a complaint with the board, like with the licensing board, starting a lawsuit. And so again, I think it is all about communication and making sure that your patient understands it. It's not a bad idea if your patient understands all of the training you had to have, too, right? So, and making sure that they, advertise all of the training you have. Understanding, how much experience you've had in that particular therapy. I think those are things that can definitely minimize risk.
Agreed.
For sure.
Agreed.
Excellent. Shifting gears now a little bit, let's talk a little bit about, I know we kind of chatted a little bit already about peptides. One of the things that we see in the compounding pharmacy world, there's 2 kinds of compound pharmacies. There's a 503A compound pharmacy, which is patient specific. And there's 503B compounding pharmacy, which is kind of bulk mass produced to then have practices kind of distribute out to their patients. And I ask this only because I had just gotten this question in our training academy is, how do you guys handle when kind of you have patients on semaglutide and they're going to a practice and picking up pre-filled syringes of semaglutide and taking it home and administering that? And so I of course had a lot more questions. I'm like, is it labeled? Is it identified? Is it coming from the pharmacy that way? Or is the practice drawing it up and labeling it? Because other things to think about is like, are they doing it under a sterile hood? What are the control? And like, I know nothing about compounding, but like all those other things, have you guys encountered any of that as far as like practices drawing up as like pre-filled syringes and then like dispensing it from their med spa? Is that something either of you guys have seen?
I will first say that regardless, like you said, 503A is prescription, right? It's for individuals. 503B is more kind of that bulk compounding. 503B they have a higher standard when it comes to kind of the manufacturing standards. Not with 503A does too. It's just on a smaller scale. They are both subject to the FDA. So kind of those. Because I've had 503A compounding pharmacies have FDA walk through their door unannounced, which is super scary, but that does happen. And so at the get-go, that's kind of the difference. I think you raise a really interesting point, regardless of kind of where you source, right, that particular drug. I mean, I think it's something that you definitely need to have policies and procedures about. How, if you are, drawing the syringe and then giving it to the patient, is there, like, what kind of standards do you have with respect to cleanliness and keeping it sterile? I think Shamika probably has more thoughts on it because she has her OSHA background on it. but again, it's all about documentation and making sure it's the training and how are you keeping it sterile and what is the kind of the chain of custody. Those are the kind of operations and questions that I would have as a patient. And if something went wrong, those are the types of things that I would want to know as a patient. And as a lawyer, that's what I would first ask my clients to send me. So.
Well, and I think from like my legal hat is like, is that even allowed in certain states, right? Because often only certain practitioners can dispense. And sometimes the states define dispensing as putting it in another vial from stock and putting a label on it. And so something that's just in a syringe, that practice in itself may not even be allowed pursuant to the state laws or that scope of practice. And so that creates, aside from OSHA, like other safety issues. So I think all of those elements, come into piece when you're looking at your policies and procedures. And to bring it back full circle, standard of care, like, does that meet the standard of care? Is that proper practice? You have policies in place to do that. Is the patient informed of where that's coming from or how that's been or how it's been stored? All of that circles back to operating under that standard of care.
Yeah, absolutely. Absolutely. Going along with that, one of the big things that I'm sure you guys have seen is, the online HerMDs of the world and HIMS MDs of the world and all those things, which can be great because you're giving more access of care to patients. How does that necessarily work when it comes to, like, are they practicing in like telehealth, like, laws as far as like for example, like in Indiana, if we are doing any kind of telehealth, we require our patients to come for a face-to-face every 6 months. And that is because we aren't practicing telehealth. We're offering virtual care in addition to our on-site care. Is there anything in like the world that you guys have seen to making sure that those guidelines are being followed?
I've seen a lot of states, as telehealth has expanded, that have started to give more specific guidelines on what it takes to establish a valid practitioner-patient relationship. That doesn't always include an in-person visit, but it does have certain requirements as far as like documenting the history and asking questions and certain elements as it relates to getting conformed consent and also advising the patient, if you start to have these effects, you have to be seen by an in-person practitioner and things like that. So I think states are starting to address that. A lot of states are starting to have rules, obviously, that you can't just get a prescription or establish a relationship via an online questionnaire. And so, we've seen the explosion of telehealth in the past few years, and now we're starting to see, I think, more rules and regulations address, like, what does it mean to establish a valid practitioner-patient relationship? What does it mean to meet the standard of care? And what are the technologies when you're engaging in those different types of relationships for prescribing purposes specifically?
And I think that's not just from the licensing. I mean, if you do take insurance, I think that's also payer requirements too, that what constitute a valid telehealth visit, and then how do I get legitimately paid for it by insurance? So those are kind of the things too that you kind of need to think about, which, it's not the ones that you're talking about, but those are also questions that we get to.
Well, I think that kind of circles back to something we talked about, offline a little bit before here. That's why those relationships where you have certain practitioners there just to prescribe, let's say a chiropractor and then a nurse practitioner that's doing prescribing are not always valid because that nurse practitioner still has to establish their own patient-provider relationship. You can't rely on communication from the chiropractor in order to give a script or provide care for those same reasons.
Right. No, absolutely. Absolutely. I think that's absolutely key on that. Shifting gears a little bit with that, the next big thing that, in the integrative hormone optimization role that we get into is the prescribing of controlled substances. And so we take shadows all the time from all over the country. And one of the things that we always want to point out is how do you store your controlled substances, specifically testosterone? What are some of the things that you guys have seen in practice? And I say that only because our Indiana law says one thing, but to be held to the high, which is like federal law, you're going to always be, oh no, I'm sorry, I have it backwards. Indiana is actually a higher, more restricted law than what federal law is. And so we have to have ours behind 2 locks. And so what are some of the things that you guys have seen on that?
Yeah, I think, just to level set for those that don't know, controlled substances operate in a closed system. The manufacturer, use, and possession is regulated by the government. There's federal requirements that everyone has to meet, and then states are allowed to have more specific requirements for controlled substance, more stringent requirements for controlled substance. The reason they're controlled substances is because sometimes they have different medical uses, and then like a higher propensity for like addiction or abuse. I think heroin is a Schedule 1 controlled substances, which just has no medical use. And then Schedule 2 is, oxycodone. Schedule 3, I think, is where testosterone falls in there. And I think the reason that like Indiana has those more strict substances is because, again, that propensity for abuse, that propensity for use. And so having them locked, the fact that it's in a closed system, they have to be accounted for. So if you lose a certain amount, that has to be reported to the DA. If you think an amount is lost, that has to be reported to a DNA. If you want to buy a certain amount, like everyone who touches that substance has to be registered, and those amounts all have to be registered in the DA so that can be tracked. Also, if you suspect suspicious ordering or prescribing, if I'm a pharmacy and all of a sudden I have a practitioner that's prescribing an inordinate amount for their patient population, and I think that there might be some suspicious ordering, saying they're ordering it and then, selling it to someone, out the back door, then the pharmacy has the obligation to report that too. And so, I think states have the ability to add substances to the federal list, even though the federal list is the minimum that has to be scheduled, and then make more stringent requirements. So I think that's kind of what you're seeing, if that answers the question.
Yeah, no, that's perfect. That's perfect.
I've also seen recently that I went to it's a big pharmacy, but in addition to kind of the cages that the drugs were housed in, if you had to go in there, people were required to like roll their sleeves up, and so I guess my whole point in lift the hem of their pants up and kind of turn around, you might make sure you're not walking out or in with controlled substances. And I guess my point is you take it seriously, because we've definitely seen it's always a fire drill when clients call and they say, hey, we just found out that there's like X number of controlled substances missing, and then all of a sudden it's just like, your whole day blows up, and there's forms you need to fill out, there's interviews you need to conduct. It is just a big deal. So besides making sure that you understand the regulations, I think, again, full circle moment, make sure you do training that your personnel understand the rules, and I guess just take all that seriously, because the law is the law, and you are held, you're going to be held accountable to protecting those drugs.
Absolutely. No, that's perfect. That's perfect. Well, thank you guys so much for taking the time out of your busy schedules. If there are listeners who want to work with you, what is the best way to do that?
Well, they can email us at my email is my first name dot last name at quarles.com, and Quarles is spelled QUARLES.com. And again, my name is Wakaba Tessier, and Shamika, I'll let you.
Yeah, my email is exactly the same. First name dot last name at quarles.com. I just want to thank you, Lexi, for the opportunity. Yeah. It was great to hop on and chat and talk about pharmacy and practitioner scope and all the things that we love.
Yeah.
So
No, this is perfect. I will link all of your contacts in the show notes because, like I said, we get questions all the time in our training academy, and so finally we have some great attorneys that we can refer to because I hate when people say it's the Wild Wild West. It's like it is, but it isn't. You just gotta know who the right people to talk to, and then like don't wait for it to like some bad shit to happen before you're like, oh, I needed consent for that. Yeah, you did. So I thank you guys so much. You'll catch this on iTunes, Spotify. I'll link all their goodness in the show notes. Have it on Reels, all those great things. So thank you so much, ladies, and I really appreciate you taking your time to share all your knowledge and smarts when it comes to legalities in regenerative medicine, aesthetic medicine, and all those things.
perfect. We'll have a great one.